Welcome back. At the courts, more lawyers have joined in speaking up about some of the challenges facing the judiciary. They also proffer some solutions that could work, especially in this new legal year.
Speedy dispensation of justice. You recall that in 2015 we had the AJC Act, that's for criminal litigation, and recently we've had reforms in the Federal High Court rules and the Lagos State High Court rules, all for speedy dispensation of justice. But in spite of that, we have not been able, I think it's a systemic thing, we have not been able to maximize the benefits of those reforms. Personally, I have some views on, let's take a civil procedure. I think there's need for an audit or review of matters that go for alternative dispute resolution, ADR. Because I think most times, some might argue otherwise, most times some matters are resolved that way. But if there's an audit of it, so that we can find the percentage of matters resolved that way, because you see the High Court rules, it makes provisions for amicable settlement. And I want to believe that before that is even, before you even go into litigation, all that must have been explored. But in spite of that, we still have to go for ADR. Now, how successful is the ADR? Some matters are resolved in the ADR, but what percentage? If we're not making any headway in the ADR in terms of percentage of matters resolved, then I think it needs some kind of review. Because we have some other form of mediation in civil procedure, case management. Well, that's also open to debate. Sometimes you go for case management and matters are still not resolved. Now, what happens there is that you might have wasted 3 months trying to mediate on such matters. And at the end of the day, it will now have to go back for trial. It goes back to the admin judge and all that. 3, 4, 5 months are wasted. These are apart from all those interlocutory applications. But I must say that the reviews in the State High Court rules for civil procedure and the one for criminal procedure, they are quite impressive, but it's just how we can walk them through. Then when you go to, just recently, I think it was in July 2019, we have a review of the AMCOM Act. Before the review, cases are supposed to go, is it day to day or, speedy AMCOM matters. But with the new rules now, it's still the same thing with a lot of reviews that make it possible for us to quickly get results in AMCOM matters. So if those things are followed through, I think it will be much better for the judiciary. Not to talk about the perennial problem of funding that has always been there. We can see some improvements in infrastructure and all that, but a lot still has to be done.
We need more judges. Our judges presently are overstretched, if you ask me, because there's no judge in a week that doesn't, in Lagos for instance, who doesn't handle more than 100 cases, because they have, you look at costlies, 30, 35 every day, and there are no supports in terms of both staff or machinery. So going forward, I think there need to be some investment there. Encourage those who are there a great deal. I don't know what is on ground for their health, because I can tell you, I do just one side, they do both sides. I know the challenges. So if it's tough for me, I can only imagine that it's double for them.
The first challenge the judiciary has is with respect to financial autonomy. You see, the judiciary, even though, quote, it is an arm of government, but when you look at the principle of separation of power, it does not apply, because there is an interference with the executive and the judiciary. So when there is such an interference, you do not expect the judges to operate fairly. I will give you a perfect example. During the General Bar Conference that was held in Lagos recently, there was a chief judge of Edo State who categorically stated that, see, I have a governor who is paying my bills. So if there's an issue, who do you expect I support? It has to be the governor. You see, that financial autonomy has to be rectified first before you can say there's truly an independent judiciary. Then issue of technology is very key. I've always been an advocate of technology. Technology makes things easier in this world. We live in the 21st century where technology is very key.
Let the judiciary be completely independent and we are going to see better results. The judges are trying under the circumstances they are. They go caps in hand, begging for funds. And you know that they can be manipulated. And some of them are even afraid to take decisions because you don't have jobs to give them. I don't have jobs to give to them. They have to manage. There's too much employment in the country. So what if we are serious about justice in this country, there must be complete independence of the judiciary. They have to control their funds. They have to control the day we work. They should not be under. The constitution is very clear. They are not supposed to be under the executive or the legislature. Let everybody play his part, and then we'll see progress in this country. It's the way the thing is structured that we are having problems.
The judiciary is an arm of government. We seem to forget that it is one arm of government that is overburdened. I've just finished a matter in the High Court, in the Federal High Court 10. Now you see the conditions under which our judges work and under which the lawyers present their cases. In a small courtroom, you have over 50 people, and you want the best from the lawyers, and you want the best from the judges. I was here during the vacation, and you could see 2 judges or a judge sitting over 50 or so cases. You cannot expect the best in such a situation. You want the registrar to send you notice before the matters are heard, when the matters are filed, a day before they come before the court. So we need to lessen the burden. Have more judges, have more courts. And that way, the justice for the common man and the lawyers who go to court to argue their cases will be, the atmosphere, the working condition will be a lot better.
On the home stretch, we have a recap of some of the top stories from the courtrooms.
We begin at the High Court of the Federal Capital Territory in Maitama, Abuja, which has dismissed the no-case submission filed by a former National Publicity Secretary of the People's Democratic Party, Olisa Metu. Metu filed the application in a bid to stop his criminal trial for alleged destruction of evidence. Justice Ishaq Bello, who dismissed the application for lack of merit, refused to stop the trial and instead ordered him to open his defense. The Economic and Financial Crimes Commission is accusing the former PDP spokesperson of destroying his statement, which he made under caution to its operatives and investigators on January 5, 2016. The commission alleged that Mr. Metu committed the offense while in its custody over allegations of fraudulent receipt of 400 million naira from the office of the then National Security Advisor, Sambo Dasuki. Still in Abuja, the Federal High Court is set to hear an application seeking the variation of bail conditions it imposed on the convener of the Revolution Now protest, Mr. Omoyele Sowore, and his co-defendant Olawale Bakare. On October 4, 2019, when the 2 men were granted bail by the court, the defendant's lawyer, Mr. Femi Falana, Senior Advocate of Nigeria, described the condition attached to the bail as stringent. In his ruling, the judge admitted Sowore to bail in the sum of 100 million naira with 2 sureties in like sum. The 2 sureties must have landed property in Abuja worth 100 million naira each and must be residents in the city. Aside that, the judge ordered that one of Sowore's sureties must deposit the sum of 50 million naira in the court's bank account as security. She also ordered that the sureties who must swear to affidavit of means are to produce in court evidence of tax clearance for 3 years. For Sowore, the court ordered the activist to deposit his passport in the registry of the court. She also barred him from traveling outside Abuja pending the period of the trial. A governorship candidate in Kogi State, Natasha Akpoti, has filed a suit before the Federal High Court in Abuja asking for the disqualification of Governor Yahaya Bello as a candidate in the forthcoming November 16 governorship election in the state. In the suit, Akpoti anchored her request on Bello's alleged double registration as a voter. Apart from disqualification, the plaintiff also asked the court to bar Bello from holding public office for 10 years. She further wants the court to compel the Independent National Electoral Commission to thoroughly investigate the act of double registration and to immediately prosecute him upon the expiration of his first tenure in office as governor of Kogi State in January 2020. And we round off with the report that a Katsina Chief Magistrate Court has remanded in prison custody a 78-year-old cleric and owner of DAURA Rehabilitation Center, where inmates were being subjected to inhumane treatment. Malam Bello Abdullahi was remanded in custody alongside 2 others for alleged criminal conspiracy, wrongful confinement and cruelty to children.
And that's our program this week. Thank you very much for watching. Be sure to catch the repeats on air or watch via our YouTube channel. I'm Shola Shieli. See you next week.